Today's session is about alteration of the matrimonial property system, that is changing from one specific marriage contract, or for example, in community of property, to out of community of property, changing the matrimonial property system that the spouses are married under into another one. Alteration of the matrimonial property system is regulated by Section 21, subsection 1 of the Matrimonial Property Act. Spouses must jointly, in other words, they must together apply to court for permission to change the matrimonial property system. If one spouse wants to change the matrimonial property system, but the other one does not want to, the application cannot be brought to court. And the application must be brought to the High Court. It does not belong to the Magistrate Court or the Regional Court. To succeed, the spouses must comply with the following below requirements. We've got the statutory requirements, which are, firstly, there must be sound or good reasons why the parties want to change their matrimonial property system. Secondly, all creditors must be given notice of the proposed change. These creditors are any creditors who is owed 500 rands and above. Thirdly, the spouses must show that no other person or third party will be prejudiced by the change. The sound reasons, or the reasons that the parties must give are just on a case-by-case basis. So each case depends on its own facts. For example, in the case of ex parte clause, the parties they has said that they were ignorant of the consequences of a community of property when they got married. That was their reason. And in ex parte pressure, the spouses thought that they could get married out of community of property by making a declaration to the marriage officer. So basically, the argument was they were not aware that they had to enter into an antenuptial contract, and it was they had to enter into an antenuptial they did not know that they had to enter into an antenuptial contract. They merely assumed that they should just make a declaration in front of the marriage officer who was solemnizing their marriage. And in ex parte Sanders, the parties entered into a valid antenuptial contract. However, they later discovered that it was not properly entered into. There was a mistake that was done, and as a result, it nullified the antenuptial contract that they had entered into. And then in ex parte Becker, the spouses applied to change from a complete separation to the accrual system because the husband's business had grown and the parties wanted to make sure that the wife will have a share in the husband's estate. So there is no specific reason, but the parties must give a reason that will be satisfactory to the court, the High Court. Also, please be aware of the differences between changes of the matrimonial, of the spouse's matrimonial property system and post-nuptial registration. In ex parte Sanders, the antenuptial contract was never registered due to the fault of the attorney. The parties successfully applied to court in terms of Section 21 of the Matrimonial Property Act to change their matrimonial property system. An argument can be made that the court should have approved the application, as changing the matrimonial property system was not the issue. So basically here, the argument is, if the antenuptial contract was not registered at the deeds office, when the parties bring in a high court application, that application cannot be deemed to be a change of the matrimonial property system because the parties had entered into an antenuptial contract, and the only thing that they needed was for permission from court to have it registered late. In other words, registered after they had gotten married. From the onset, it was never their intention to get married in community of property. So accordingly, the court order should have been granted in terms of Section 88 of the Deeds Registries Act, which allows the spouses who entered into an informal antenuptial contract to apply to court for permission to have the contract formally executed and registered postnuptially, in other words, after they have gotten married, in order for it to be binding on third parties. And in the case of ex parte Engelberg, the parties agreed to get married out of community of property. However, they did not enter into a formal antenuptial contract due to lack of correct information. They were under the impression that they only needed to do a declaration to the marriage officer. So they later succeeded in bringing a court application in terms of Section 21 subsection 1 of the Matrimonial Property Act. So the difference between Section 88 of the Deeds Registries Act and Section 21 of the Section 21 subsection 1 of the Matrimonial Property Act is that if the parties have, or the spouses had entered into an informal antenuptial contract, which is only binding on the two of them, but is not binding on third parties, they can bring in a high court application in terms of Section 88 of the Deeds Registries Act to request the court for permission to have the antenuptial contract registered at the deeds office, so that it's going to be binding on the third parties and on them as well. Although informal antenuptial contracts are binding on the parties themselves, but they are not binding on third parties. So Section 88 of the Deeds Registries Act gives them the powers to make sure that that informal antenuptial contract, it is formalized, it is registered at the deeds office, and it becomes binding on third parties. And then Section 21, subsection 1 of the Matrimonial Act is when spouses who, for example, have gotten married in community of property, and they now request permission from the High Court to change from in community of property to out of community of property. Students, it is very important that you know the difference between these two provisions. Now let's move on to retroactive alteration. The question here is, can a matrimonial property system be altered retroactively? So in other words, let's say today, it is the 11th of April 2023, and the parties have made a court application. And now the question is, can the court grant an application whereby the new matrimonial property system will also be binding on transactions that took place, for example, before the 11th of April 2023, or is going to be binding from the date that the court order is granted? And the answer here is unclear. We've got a conflicting judgment. So as of now, each case is judged and is based on its merits. For example, in the case of ex parte crossing, it was held that this can be done. And then in the case of ex parte Oosthuizen, the court held that it does not have the power to change the matrimonial property system with retroactive effect. Please also, in your prescribed textbook, just read what the court said in ex parte Berger. But the important thing that you need to know here regarding changing matrimonial property system retroactively is that the position is unclear and each case is just based on its own merit. Extrajudicial alteration of the matrimonial property system. Spouses who want to amend the matrimonial property system to operate against third parties must follow the processes in terms of Section 21, subsection 1 of the Matrimonial Property Act or Section 88 of the Registries Act. This is what I've just spoken about, and please just know just know these two provisions. Also, please study the case of Honey versus Honey. Okay, students, this is just a brief summary of alteration of the matrimonial property system. Please, as I always say, please make sure that you study your prescribed textbook, you study the study guide, and you study all the relevant tutorial letters. Again, I want to repeat that. Firstly, just make sure that you have a basic knowledge on family law, on how these different study units work. Like, for example, I've just given you just a brief summary of how alteration of the matrimonial property system works. So if you have a basic knowledge of how actually everything works, it's going to make it easy for you when you now thoroughly study to know the relevant provisions, to know the relevant court judgment. And remember that your exam is an open book, it's a multiple choice open book. So you will be having your prescribed textbook, the study guide, and all the relevant tutorial letters and all the relevant notes that you have acquired for yourself. It is going to make everything easier for you for the exam and also for the assignment. So my advice to you is, before you start interrogating the relevant provisions, the relevant court judgment, just read your textbook and just make sure that you have a basic knowledge that, okay, income of property means this, out of community of property with the accrual system means this, out of community of property without the accrual system means this, and the alteration of the matrimonial property system. This is what it entails. And once you have that, it's gonna make things very, very easy for you. As always, students, if you need any clarifications on the recordings or the information that we have shared in the recordings, please feel free to send me or my other colleague, Mulibati Sierrani, an email. My email address is monark@unisa.co.za. Good luck with the exam, students, and we shall see each other on the next recording. All the best with your studies.